The Premack Virtual Online Law Office presents attorney Paul Premack with this week's legal column, published in the San Antonio Express News on mysa.com and on our website at www.premack.com. This week's topic: is this battle sibling rivalry or parental choice? Dear Mr. Premack, my mother is 91 and lives about 5 hours from here. My sister has durable power of attorney, and I am backup agent. My brother lives with mother and is draining her of all of her money. Can he legally get my mother to go and change him to have power of attorney? Signed, NF. Your brother may be financially exploiting your mother. I say may be because you are not an objective third-party observer. It may be that your mother, though 91, is competent, capable, and clever. She may love having her son in the house, may find that it is a great deal to help support him while he watches out for her, or he might be illegally abusing and exploiting her. The best way to handle this situation is to make a report to Adult Protective Services. They are part of the Texas Department of Family and Protective Services. To report to them is confidential and will be acted on promptly. You can file a report online at www.texabusehotline.org or by phone at 800-252-5400. As to the power of attorney, your mother is the decision maker. When you ask, can he legally get my mother to go and change the power of attorney, the legal answer is no. Only your mother has legal authority to create or to change her power of attorney, and she must do so voluntarily. However, if he is exploiting her, he may be able to pressure and influence her into something she would not otherwise do. You need to maintain close ties with your mother. You need to see her face to face on a regular basis. You need to inform her lawyer of your brother's possible nefarious activities, so he's on the alert for undue influence. You need to honor the choices that she makes if she's going to do so voluntarily and with full capacity. But if she's being exploited, is unable to make decisions on her own, and has lost capacity to manage her finances or personal choices, you may have to seek to become her court-appointed guardian in order to save her from your brother's abuse. Dear Mr. Premack, I just recently found out that my uncle passed away in 2006. If he had a will or anything of an estate, why would the state of Texas not have notified his next of kin? He was my dad's oldest brother. If there was a will, is there any way for me or my siblings to get to see a copy of the will? Signed, RSM. The Texas probate system is not set up with the state as an active participant. It all happens on the county level. When a will is offered for probate, the county probate court takes the role of supervisor/referee. The court's clerk posts a public notice at the courthouse, but is not required by law to issue any other notifications. After the will has been admitted to probate, the executor is required to send a copy to each named heir, but that's only been a legal requirement since late 2007. Consequently, if your uncle's will was probated in 2006, the executor would not have been required to send any type of notice directly to any interested party. Instead, back then, it was sufficient that the will had become a public record, which could be viewed by anyone interested enough to make an inquiry. If he did have a will that was probated, then it's still public record. You should visit the courthouse in the county where your uncle had resided. Ask the clerk for assistance in searching the probate records. You can then obtain a copy from the clerk.